Welcome to the EPG Pathshala. I'm Dr. Rupneet Lali and I will be dealing with the module on meaning, aims and types of punishment. The learning objectives are to be able to understand the meaning of punishment. Second is to articulate the different aims of punishment. Third, to understand the changing modes of punishment. And finally, to distinguish between the different types of punishment. Well, punishment of wrongdoers is as old as wrongdoing and as old as society itself. The 18th century Enlightenment thinkers, upon whose ideas much of the world's criminal justice systems are based, were of the opinion that punishment was a necessary evil, a price paid for the comfort of living in an ordered society. Societal reactions to violations of law, in most cases, take the form of punishment. How do we define punishment now? According to Aristotle, punishment is required to maintain equilibrium in the society. Criminal law prohibits certain behavior which are deemed as harmful to society as a whole, whereas the civil law governs the private interactions between individuals. And that's the difference between both of them. The Black's Law Dictionary defines punishment in criminal law as any pain, penalty, suffering, or confinement upon a person by the authority of the law and the judgment and sentence of a court for some crime or offense committed by him or for his omission of a duty enjoined by law. According to Sutherland, punishment is inflicted by the group in its corporate capacity upon one who is regarded as the member of the same group. 2. Punishment involves pain or suffering produced by design and justified by some value that the suffering is assumed to have. According to Ferry, punishment is a legal deterrent. Jeremy Hall described punishment in the following terms. Punishment is inflicting pain, it is coercive, it is inflicted in the name of the state, that is, it is authorized. It also presupposes rules, their violations, and a formal determination expressed in a judgment. It is inflicted upon an offender who has caused harm. And third, the extent or type of punishment is in some defended way related to causing commission of the harm and aggravated or mitigated by the reference to the personality of the offender, his motive, and the temptation. Punishment is thus the penalties which are imposed by the state on an individual who violates the criminal law. It is the society which defines the offenses and prescribes the punishment for them. The kinds of punishment that are given are influenced by the kind of society one lives in. For example, during the ancient period, punishment was very severe and it was the prime instrument for preventing crime. In criminal law, punishment is allowed due to the wrongful intent, that's the mens rea, involved in the crime. The law does not really punish the individual, but punishes the guilty mind. Justifications for punishment typically take 5 forms: retributive, deterrent, preventive, rehabilitative, and restitutionary. There are limitations on a punishment that may be imposed. Some modern forms of criminal punishment reflect a philosophy of correction rather than or in addition to one of the penalties. So, summarizing the concept of punishment, one can suggest that punishment includes the following areas. First, punishment is inflicted, it's a feeling of uncomfortable or unpleasant circumstances, involves deprivation of certain normally recognized rights, and thirdly, it's a consequence of a wrongful act, that is an offense, and there must be some relationship between the punishment inflicted and the crime committed. Punishment is a form by which a criminal is made answerable to society, and it is applied by the state against an offender. What are the aims of punishment? Why do we punish? The role of punishment in modern society is an extremely complex and intricate process, and justifications for which to a large extent are ambiguous. Duff and Garland in 1994 explained punishment requires. Why does it require justification? Because it is morally problematic. It is morally problematic because it involves doing things to people that seem morally wrong. It is usually wrong to lock up people. and bringing the offenders to justice is a primary function of all civil societies of all states. There are primarily two different views on punishment. One, the group believes that inflicting punishment, pain as a punishment, is fundamentally different from inflicting pain on innocence and therefore is not inherently wrong. And another group believes that punishment is a wrong that can be justified only if it results in a greater good. And those who hold the first view do not feel it's necessary to justify punishment beyond the fact that the individual deserves this. And this is the retributive approach. The second view, however, justifies punishment through the secondary rationales of deterrence, incapacitation, rehabilitation, and this is known as the utilitarian approach. Now, if we look at the major driving force underlying all punishments is revenge, and it is retribution. Retribution word is derived from the Latin word meaning to pay back. In retaliation for wrongdoing, society seeks to punish an individual who violates the rules. Criminal punishment is also intended as a deterrent to future criminality. Offenders who are punished may be deterred from future wrongdoing because they fear additional punishment. Now, the various goals of criminal punishment may conflict with one another. For instance, take the goal of incapacitation, which is achieved by confining offenders for long prison terms. However, inmates who are warehoused in large prisons where they associate closely with the other criminals, they lack control over their life, they may develop antisocial behaviors. And therefore, the object of punishment has been stated by Halsbury laws of England as the aims of punishment are now considered to be retribution, justice, deterrence, reformation, and protection, and modern sentencing policy reflects a combination of several or all of these aims. The retributive element is intended to show public revulsion to the offense and to punish the offender for his wrong conduct. The concept of justice as an aim of punishment means both that the punishment should fit the offense and also, like offenses, should receive similar punishments. An increasingly important aspect of punishment is deterrence, and sentences are aimed at deterring not only the actual offender but also further offenses by potential offenders from breaking the law. The importance of reformation of the offender is shown by growing emphasis that has been laid by modern legislation. Now, what are the different types of punishments? We've had different types of punishment throughout history. The standard punishments in ancient Greek and Roman societies were death, slavery, mutilation, corporal punishment, imprisonment or banishment were also common forms of punishment. Now, whether they are corporal or not corporal, they can be divided. Petty criminals may be sentenced to a combination of both corporal punishment and incarceration in jail for several months. The punishment for more serious offenses was usually death. The maximum punishment is usually set out in the legislation of any country along with the offenses. And it is the courts which decide what sentence, what penalties are to be imposed upon the offender, taking into consideration some of the factors, like what mindset was there, and it also involves forfeiture or deprivation of political or civil rights, deprivation which is rendered, or the person may be incapable of office, compulsion to remove some influences, nuisances. Different types of punishment may be fines, detention, house arrest, custodial sentence, life imprisonment, capital punishment, electronic tagging, which is a new kind of a punishment which is being given, penal harm, and psychological punishments, public humiliation, painful humiliation. These were different types of punishment. The term punishment has not been defined in the Indian Penal Code, and Section 53 of the Indian Penal Code, that's the IPC of 1860, prescribes 5 kinds of punishment. First is death penalty, life imprisonment, imprisonment which may be rigorous and simple, forfeiture of property, and the 5th is fine. The capital punishment is the most severest form of punishment that can be given. And capital punishment is the practice of deliberately putting to death of an offender as a measure of social policy. And it is imposed by the governing authority of a country. Capital punishment is generally imposed for the most grievous, most heinous offenses that a person can commit. and capital punishment is also the most debated subject amongst modern penologists. The methods of execution have varied over time. Some popular forms of execution of punishment have been stoning, guillotine, hanging, and in some countries you have the electric chair. In ancient times, even in the Middle Ages, sentencing offenders to death was a very common form of punishment. In England, in fact, the legal system became to be known as the Bloody Code between 1688 and 1815. And until the 19th century, death penalty or capital punishment was imposed for more than 200 different types of crimes. The IPC has prescribed death punishment as a maximum punishment. And it is prescribed for a number of offences which include treason, abetment of mutiny, murder under section 302, which is popularly known, kidnapping and ransom, and dacoity with murder. Death penalty continues to be used under section 302 in India. Additionally, many other special legislation such as the Army Act, the Navy Act, and SC/ST Act, and also Explosive Substances Act also provide for death penalty. The sentence is awarded in the rarest of rare cases. According to the IPC, the punishment of death sentence is not mandatory for any crime. Before 1983, it was mandatory under section 303 for a murder committed by a person who was already undergoing life imprisonment. In Bachan Singh versus State of Punjab 1980 Supreme Court case, the Supreme Court was faced with the question whether death penalty imposed is constitutionally valid or not. And the Supreme Court ruled that the death penalty is constitutionally valid and does not constitute an unreasonable, cruel, or unusual punishment. And the majority pointed out that it is imposed only for special reasons and only in the rarest of rare cases. However, such provisions cannot be considered as violative of Article 21, 14, and 19 of the Constitution. Today, many countries have abolished death penalty either by legislation or in practice. And a few have essentially abolished it while retaining it for particularly heinous offences, though it has not been used for many years. Deportation or banishment was used as an alternative to death penalty for very dangerous offenders in the ancient times and who were considered undesirable, criminals with political or religious dissidents or banishment. That used to be the solution. And it was seen that in certain places, in certain countries, for example, Britain, they deported religious objectors and criminals to America and Australia in large numbers. And more than 160,000 prisoners were sent to Australia or Africa to work in the labor colonies they established. In Russia, for instance, prisoners were transported to Siberian penal camps. So banishment or transportation cannot be a solution to the problem of crime and it really does not meet any purpose of incapacitation. And this was abolished in England a long time ago, and it has also been abolished in India. In India, it used to be called transportation, where it was popularly people were sent to Kalapani and they were mainly freedom fighters who were transported to the Andaman and Nicobar Islands. It was abolished in 1955 and replaced by imprisonment for life. Deportation involves expulsion of a person or a group of people from one place or a country to another place. Now, the expulsion of foreign nationals is usually called deportation, whereas expulsion of nationals is called banishment. So, you will have deportation of, let's say, persons who have illegally entered the country. The third type is corporal punishment. Throughout history, societies have used corporal punishment to inflict physical pain on wrongdoers. And until the 19th century, corporal punishment in England could consist of whipping, branding, and the cutting of body parts. A pickpocket, for example, could have had his hands cut off. These have now been discontinued, being considered barbarous and cruel in form. Corporal punishment includes mutilation, flogging, whipping, and torture. This was a very common form of punishment in the ancient and medieval times. And right up to the Middle Ages, whipping in public was one of the commonest forms of punishment. It was also a very severe form of punishment where sometimes even prisoners bled to death as a result of the wounds received by the lashes. And the main object of this punishment was deterrence, that it would create fear in the public who would see this. Whipping was abolished in 1955 in the IPC. And less than 20% of the world's countries today have prohibited by legislation the use of corporal punishment. as a sentence for crime or for use in prison discipline. Medically supervised caning is regularly used. Can you guess in which country? Singapore. Now, the fourth type of punishment is imprisonment. It was originally used as a means of detention till the trial was completed or a debt was paid, therefore debtors' prisons. And the earliest use of imprisonment dates back to the 9th century. Prisons in modern sense became the prominent form of punishment just about 200 years ago. The IPC sanctions either a term of imprisonment or fine or both, and it is left to the discretion of the court whether to inflict a sentence of imprisonment or a fine or both. The lowest term of imprisonment is 24 hours, is prescribed under 510 of the IPC. Life imprisonment. The number of offenders who have sentenced to prison for life has grown, especially after the Second World War. And it's a trend. Today we have 10.35 million people who are held in penal institutions throughout the world, either as pre-trial detainees or having been convicted and sentenced, as per the World Population List of 2015. If imprisonment is properly used, it may serve the three important objects of punishment. That is, it can be a deterrent, because obviously it makes an example of the offenders to the others, so it serves a cause of general deterrence. It may also be specific deterrence, since that person for that particular time is inside the prison. But again, we find that sometimes you have persons who may be in prison, may be committing crimes while sitting inside the prison. So the specific part of the specific deterrence may not be really there. Imprisonment may also be preventive because it disables the offender for some time from repeating the offense. And if it is properly used, and imprisonment can give rise to a sort of reformation that can occur, well, if there are proper opportunities that are given to the prisoner to reform the character and to learn new skills and to unlearn the wrongful attitudes or wrong behavior that has been learned as such. Imprisonment may be now both rigorous or it may be simple. What does rigorous imprisonment mean? Rigorous imprisonment is of such type where the convict will have to do hard labor. A person may be sentenced to imprisonment for 10 years, maybe with 5 years rigorous imprisonment. It serves as a deterrence to prospective criminals, where the person may be forced to do some labor. It's not just idling away. Whereas simple imprisonment, the person is confined to a jail and is not put to any kind of work. If asked to work, it will be of their own choice and will be paid wages. Now, Section 57 says that the maximum imprisonment for any offence that can be awarded is 20 years. Now, this distinction between rigorous imprisonment and simple imprisonment, in fact, in our country now, it has almost ceased. Why? Because prisons are not able to provide for work for all offenders who are serving their life sentence. So, some of them may be just whiling away their time, and it may be just a simple imprisonment. So this distinction between rigorous and simple imprisonment, today we are saying that it needs to be removed. And you have another kind of punishment, which is solitary confinement, which is an aggravated kind of imprisonment. It keeps a person thoroughly isolated from any kind of contact with the outside world. And here it is conflicted with the view that feeling of loneliness may produce an influence on the criminal, who may think and introspect and reform. However, it has been felt by many criminologists that this kind of punishment is inhuman, it is perverse. Section 73 of the Code empowers the courts to impose solitary confinement to certain prisoners in relation to certain offences. And this punishment is also part of imprisonment. A harsh and hardened convict may be confined in a separate cell to correct his conduct. So he is put separately without any contact and interaction with the other prisoners. The object is to reform the hardened and the habitual offenders, and in order for him to experience loneliness. However, there are certain restrictions in imposing solitary confinement. In India, solitary confinement should not exceed 3 months of the whole term of imprisonment, and it cannot be awarded where imprisonment is not a part of the substantive sentence. You do have prisoners who may be put to solitary confinement if they have committed certain offences. Forfeiture of property is another penalty in which one loses his rights or interest in his property. Now, it is meant for persons especially who have committed highly political offences or corruption, and it is not very common in the IPC. It is there provided in section 126, 127, 129 and 169, which describes forfeiture of property. It is also provided under the NDPS Act, that is the Narcotic Drugs and Psychotropic Substances Act, for the drug offenders, drug traffickers. Asset seizure is imposed as a form of financial loss. So the person may be taking a bank loan or has stolen property and does not pay back. An authority or the court may decide to confiscate his house or car or compensate the complainant. And another form of penalty is fine. It is considered to be a very minor penalty. It is imposed sometimes along with imprisonment for 5 years, along with a fine of 10,000 rupees, let's say. And the amount of fine varies for different offences. Fines are normally imposed for violations of traffic and licensing regulations. You find that for wrong driving, you may be fined. So these are the various penalties which are imposed for different types of offences. All these are specified in the law. The nature, amount of this kind of any kind of punishment, whether it is imprisonment, whether it is fine, it varies in each case and offences which are decided by the court. Now, we have some other types of punishment which are also prescribed. In fact, in India, we have something known as the special and local laws. Under the special and local laws, you will have for the juvenile offenders, which is a special law for juveniles, which is focusing on reformation. You will have different kinds of punishment. Again, you have admonition, document entry, dismissal from service instead of receiving a fine or imprisonment. A person may also be placed on probation. In fact, the Probation of Offenders Act applies to persons who have committed the offence, who are young offenders, committed the offence for the first time. In fact, under 360 CRPC, it is supposed to be based on the report of a probation officer, where an offender may be able to carry out daily activities. He must not reoffend, and there are certain conditions which are laid down to the probation, that is, he has to report to the probation officers, or there may be certain curfews that may be imposed. So the Probation of Offenders Act was a highly progressive legislation, but today we find that there is a relatively less use of probation for offenders. Another sentence that is there is also that the court will consider what was the nature and severity of the offence, what is the character, what are the chances of his being reformed. So for those who are below 21 years, for women particularly, this can be used. It's a discretion of the court under section 360, so where the person may be released on probation, and the aim is to reform the offender where he is not a serious threat to society. In some countries, community sentences now constitute other types of punishments. Where the offence is committed is not too serious, an offender may receive a community sentence instead of a fine or imprisonment. So the order requires an offender to perform some supervised community work which is associated to his offence for a period of time. And this may involve whether cleaning up, or it could be day reporting order, where the offender is required to report on a regular basis for a period of 3 to 12 months. And the Tokyo rules specify the rules for the community service. And these rules, in fact, are used in India. We do not have community sentence as a type of punishment under the IPC, and there is a call for making an amendment into the IPC to include community sentence instead of persons being merely a burden on the state, that they must serve the community, they pay for their debt, and this is a growing trend towards restorative justice, in fact. Criminologists have advocated for punishment with the sole aim of inflicting punishment. Now that has gone. The utilitarian theories are much more in terms of reformation and incapacitation and reintegration. So the focus has shifted now from the offence to the offender. People who commit crimes may be punished thus in a variety of ways. The inflicted punishment may be physical, whether it is corporal, or in terms of imprisonment. It may be economic, in terms of financial pecuniary fines. It may be psychological, or it may be social. Offenders may be punished by fines, monetary assessment, infliction of physical pain through confinement in jail or prison, capital punishment. These are all different types of punishment which we have seen have developed over a period of time. And with the change and development of the human mind, the punishment theories have become more tolerant. Worldwide, there is an increasing focus on reducing imprisonment, reduce incarceration. In fact, Scandinavian countries like Denmark and also Netherlands, they have shut down, Sweden, they have shut down their prisons. They have reduced the imprisonment rate, and crime rates have also fallen. Whereas some countries are huge incarcerating countries. The alternatives to imprisonment as a mode of punishment, namely probation, parole, discharge, community sentence, these are all which are now being sought to be increasingly used, that they must rehabilitate and heal the offender and also the victim. And today we find that restorative justice movement is back in, it's picking up in a few countries, so that the offender does not revert to crime and also pays for the crime to the victim as such. So these were the different types of punishment which have developed in different countries. Thank you.